In Wisconsin custody cases, winning isn't about who's loudest in court, it's about who's the most prepared. And the secret, making the judge's job easier. Judges deal with complex family situations every single day. Showing up with a clear, professional, and reasonable case makes all the difference. I'm Jeff Hughes. I'm the lead attorney at Sterling Lawyers. We are Wisconsin's biggest family law firm, which means we see more cases and more judges than anyone else. And that gives our clients an advantage. And in this video, I'll share with you 5 strategies that will help you present your best case and do what's right for your kids under Wisconsin law. So stay with me. By the end, you'll know exactly how to handle your custody case. You know, success in Wisconsin custody cases often comes down to one fundamental principle: making the judge's job easier. When you present your case clearly and professionally and reasonably, you help the judge make informed decisions about your child's best interest. So let me start with helping you understand the judge's perspective, because the judge is your audience. That's the person that you need to convince and sway in your direction. You know, every day, our judges face a multitude of family cases. And under Wisconsin Statute 767.41, judges must evaluate complex family dynamics and situations and fact patterns and parties. They must evaluate all of that and make decisions that will affect children's lives for years to come. So they need to process extensive information quickly while ensuring every decision serves the child's best interest. So think about it. Your judge is handling multiple cases every single day. And if you want to get a sense for how many cases your judge has to handle, when you arrive in court, go look on the outside on the wall. A lot of times the clerks will put up a piece of paper called a docket. And a docket is a list of all of the cases and times for that particular day. And you'll see just how many cases one judge handles in one single day. So it's your job when you go in there to make that judge feel like you're prepared, that you're valuing their time, and that you know what you are asking for and why you're asking for it, because a lot of folks go in, they don't know any of that stuff. And it requires the judge to do extra work to help the parties get there. So you do this by making your case stand out through clarity, through organization, not drama and complexity. Okay, so that's the judge's point of view and perspective. That judge is your audience. So think about everything you do is done to persuade the judge. Okay, so let's get into the 5 strategies. Strategy number 1, present a clear roadmap, a pretrial statement to the court. The first way, and maybe the most important way you help your judge, is to have a well-crafted pretrial statement. Think of it as a GPS system for your case. So instead of handing the judge or telling the judge a bunch of jumbled facts that don't really interrelate and are hard to organize, just think of that of like a map with no roads on it. And you're just giving that to the judge and say, figure out how to get there. Instead of that, you're providing your judge with clarity. Think of it as turn-by-turn directions on a map that helps the judge get to your desired outcome. And here's what this looks like in practice. Start with a clear overview of what you are requesting for custody and placement. Now remember, custody is decision-making for major things in your child's life, okay? Healthcare, church, school, and so forth. Placement, that's super critical. That's the time that you get with your child, okay? So when you go into court and you have requests around custody and placement, be very clear and precise in your roadmap as to what you're looking for. Now here's the key. Then systematically connect each of your requests to Wisconsin's best interest factors that are in that statute that I cited earlier. For example, if you're seeking primary placement, which means the child is with you the majority of the time, explain how this arrangement maintains your child's school stability, community connections, it's best for their well-being, and so forth. And remember this, keep it concise. Don't give the judge pages, right? Keep it concise and use your best information, your best arguments, your best evidence to support what you're asking for. And underneath all of that, undergird it with the Wisconsin law that relates to what you're asking for. Remember, more is not always better, okay? So that's why I say keep it concise, because you don't have a lot of time and you want to be able to get right to the point on the most important factors that you're asking for. All right, strategy number 2, build an organized evidence trail. Judges appreciate so much organized evidence. They can just feel overwhelmed when a party comes in and just dumps documents and all kinds of requests on the judge's desk and expect the judge to organize all that. That's your job as the party. Your job is to organize the evidence and tie that to a logical connection between what the evidence is, what the law is, and what you're asking for, okay? So simplicity wins here, folks, not complexity. And it's hard to keep things simple. It's hard to narrow things down to the most important points. It's easier just to put it all in a basket and dump it on a desk, okay? That does not work. That will end up working against you. Now, one big point on how to do this effectively is create a chronological timeline of significant events. Now, that's a judgment call on what's significant, but think about it again. In light of what the judge is looking at, make sure if you're going to put something on there that it's significant and not just a minor thing, okay? Put all that in chronological order, not jumping around, chronological, because a lot of judges, most judges think in terms of chronology. They want to be able to look back years and work their way forward to today so they can make their decision on what they see and what they find in the history of your case. And while you're doing this, maintain organized records of all of your parental activities, including everything you do with school, medical appointments, and all of those things that relate to the upbringing and well-being and care of your child. Now, here's a key. Don't just collect the information. Remember to present it in a concise, clear, organized fashion that tells your story. Remember, stories sell and facts tell, and you want to sell the judge on your story. So the more you can weave it into a story and make it chronological and present it in a way that's storytelling and done professionally, judges really connect with that. All right, strategy number 3, support your position with Wisconsin law. You know, knowledge of Wisconsin family law is your biggest ally in the courtroom. When you show your judge that you understand relevant Wisconsin law, custody precedent, and maybe even case law, if you're so ambitious, you are speaking their language. They love that. They can really connect with that and understand that because that fits in with their nomenclature and the words that they use. For example, if you're requesting sole custody, which means sole decision-making for major things, then be prepared to go to that statute that I mentioned earlier and cite where in that statute supports your position, why you should have sole custody of your child's decision-making, and be prepared to give the law for why that should be. Now, that statute, as a reminder, is 767.41, and you can certainly Google that and find that online. Get real familiar with that. Print it out and have it with you when you're in court so you can reference that. All right, strategy number 4, demonstrate reasonable behavior. And this is really hard. I get it. You're going through a family crisis and your emotions are probably at a fever high, all right? Everybody's like that. This is really, really hard stuff. But if there's ever been a time to be reasonable and control your emotions and stay calm, now is the time to do that, especially in front of your judge. Wisconsin courts favor parents who show their willingness to be cooperative, who show that they have reasonable behavior, to show that they are not outrageous in how they look at things. They want to know that once the parties move on and they're out of the court's line of sight, that they have a likely chance of being cooperative, working together with reasonable positions and reasonable behavior. So let me share with you what that looks like to a judge, okay? These are the things the judges look for when determining whether or not a party is reasonable in their approach. Documenting all attempts at reasonable communication, okay? So if you can show, hey, here's been my communications through texting or through other avenues with my soon-to-be ex, and my conversation has been reasonable. The judges will review that and look and say, yeah, this person seems to be pretty reasonable how they do things. So documenting that really helps. Show flexibility in scheduling. Now, we all know how it is with kids. There's always something popping up at the last second and, things happen. Be flexible. Don't use the schedule and don't use rigidity of your schedule to get back at the other party. Don't be like stuck in concrete and be so unwilling that you're not willing to change the slightest modification because that makes you look unreasonable. So be flexible in your scheduling. Also, maintain a respectful attitude toward the other. Now, I know a lot of times the other parent, they're not behaving in a way that's respectful. I get it. I totally understand that. But as much as you possibly can, keep it professional, keep it at arm's length, and be respectful. Courts are watching that, especially if you have other court involvement with a guardian or with a social worker or whatever. Be respectful, because the court's weighing your credibility. And if they find that you're a respectful person and the other parent's not, they're going to weight their decision in your direction. Like I said earlier, keep records of all joint decision-making efforts. So when you try to work with your spouse, keep records of that. And a lot of times that looks like text messages or emails or voicemails, those sort of things. And be prepared to discuss future co-parenting strategies, because the judge may ask you, hey, party, how would you perform in this particular situation? How would you make decisions for your child with your ex-spouse in this scenario? So be prepared to discuss all of that and do it in a reasonable way. Boy, remember, judges see so many high conflict cases, and they really are draining, even to judges who see so many of them. And you don't want to appear to be one of those high conflict parties, because judges, a lot of times, they'll just like move away from them and make a decision for the other party if they find that one's high conflict and the other one is more reasonable. Strategy number 5, make complex information easy to understand and accessible. What I mean by that is make it easy for your judge to understand your position. Think it through before you go to court. Practice describing it. Practice being concise and following kind of a logical pattern as you lay out what you're looking for. The judges don't have time to sift through all kinds of information. So the easier you can make it, the simpler you can make it, the better it is for the judge. And the more the judge is going to lean and turn your way. A lot of times it would be helpful to have charts, financial information, visual calendars for proposed schedules, organizing in a way that you are telling a story, even with like visuals and images, so the court can use that information to make decisions faster and more in line with what you're asking for. Now, we just learned how to win over your child custody judge. But what if the judge decides it's in the best interest of your child to appoint a guardian ad litem? Now, a guardian ad litem, also called a GAL, is another attorney appointed to represent the best interests of your child. Not to represent your child and what they want, but to represent what they believe is in your child's best interest. If this were to happen, if you have a guardian appointed, you need to be prepared for that and know what they do and how they go about doing that. So check out this next video about the specifics of what happens when a guardian ad litem is appointed.